Welcome back to the Photofocus podcast. It's a bonus episode in April 2023. Joining me as always is my co-host Rob Moroto, and we have back, because we missed out last time, David Deal. He's a photographer turned lawyer, and he's been a very well-received guest in the past. We wanted to have him back. Welcome, guys. Rob, say hello to everybody.
Oh, hello, and thank you, Ron, for the introduction there. I think before we get too into this, we have to thank our sponsor, Photomatics, or HDR Soft, the creators of Photomatics, and I gotta say, I'm absolutely in love with that program. It is, we are now bundling that in my online course, available at robmoroto.com, where I teach how to do real estate photography. But without Photomatics, I could not do what I do, and I've been doing this since 2009, and Photomatics has been the program of choice to make sure that all my real estate photography looks absolutely amazing. And we get nothing but 5-star reviews on our Google account. I think we've cut over 100 already, and it's great. So thank you, Photomatics.
I'm the same way. I wouldn't have had a viable business when I started out doing 360s more than it's been 20 years now, maybe almost. Nearly. And if I didn't have HDR to help out, I couldn't have really made a business out of it. So, and I'm also doing real estate photography with it now too. So yes, thanks. Go to hdrsoft.com, click download. It's free to try. The trial doesn't expire. Just adds a watermark to the processed images. And with that, let's bring in, I see David C. Deal, where the C stands for copyright.
Almost.
Almost.
Thank you very much for having me back. I appreciate the opportunity, and I love talking about the legal aspects of copyright.
We had you on, I think, late last year one time, and it was I really enjoyed it, learned a lot, and it was well received, and we wanted to have you back. And then if for those that heard the roundtable last month with Joel, it started out with being the roundtable with Joel and David, but there were some connection issues over there in the French connection was not working. So we wanted to have you back and just have a kind of a free form. We have questions for you. We have topics for you, and we'll kind of see where it takes us. So Rob, do you want to introduce the first topic?
Yeah, no, definitely. Because, there's a lot of photographers out there. And one of the things that we really get into is how do photographers promote themselves? And lately, it's on social media. Everyone posts things on social media, and they try and get the word out there. It gets shared. It gets it gets shared. It gets put out there. We wanted to start talking with David and say, social media is this really strange beast. What happens with copyright when it's on a platform like social media and things get shared? Is that copyright infringement, or is that actually a good thing, or is that permissible? What do you think? Well,
it's the way social media has been treated by kind of the general public in the past 10 years has changed. It's evolved. The starting point for whether or not social media use constitutes infringement, it starts from the position that it is infringement unless the copier is a proper licensee. That is the starting point. There is nothing, legally speaking, that allows a user of social media any kind of benefit when they copy copyrightable work specific to social media. So it is at its base level, copyright infringement is the identification of a copyrightable work and the unauthorized copying of that work. That's it. Those are the only two elements that I need to prove when I'm litigating a copyright infringement matter. Social media is no different. The tricky part. Go ahead, Rob.
So what I'm hearing from you then is that regardless of who it is that's sharing the material, if they're sharing it without permission, then it's copyright infringement.
Correct. Yeah, and while it's often the case that a photographer's original client may properly use an image on social media, that is part of the agreed upon license. It's often not the case that the license includes the dissemination of that image on the same social media site to other accounts. So just because your client and the proper licensee uses the image on social media does not extend any type of license to others that share the original licensed use. So, I mean, the way to think about it is social media, you know, it culturally, it's a little bit different than individual entities, websites that exist online. Legally speaking, it's the same. And effectively, now social media parts of an online a business an entity's online presence, it's effectively the same as content on their you know, kind of base URL. And if not, it's probably more. It's probably the viewership and the kind of the exposure that it gives an entity is probably, I would argue, greater than, and you know, every case is different, but in most cases it's probably greater than the exposure that they get from their commercial website alone.
Well, definitely. When everybody's looking for a portfolio of something, they're typically going to the Instagram to see the person's work. So yeah, I would agree with that. But I want to put out this scenario. Say I'm a wedding photographer and I go out, I shoot a wedding, and I send the pictures to the bride and groom. They send it out onto their social media. Now, because the bridesmaids were all there, the groomsmen were all there, and they start sharing it and say, wow, this was such a fantastic wedding. Congratulations, whoever. And then that gets shared out with the families and everything like that. And in that whole chain of things going out, the caterers share it out. And the caterers are sharing it out saying, hey, we hosted this. Look at the great food that we got out there. And they're using that essentially as advertising. Now, I heard from somebody saying, well, if you are going to go and attack someone for copyright infringement, you can't just single out one person. You have to get everybody. Is that true?
That is absolutely not true.
Okay, good.
There is a huge difference between what you just described. To be fair, all of it at its base level, again, is infringement. You know, the only thing that is required, along with a copyrightable work, which almost every single photograph ever taken qualifies. The only other thing that needs to occur is for there to be unauthorized copy. That's it. So if as a wedding photographer, your license extends to you know, either the bride or groom or whoever it is, the extended families of both of those individuals, that's where the license ends. And anyone outside that circle, outside the proper licensees, when they make a copy of an image, however they source the image, whether or not it's social media or elsewhere, they are on its face, they're committing infringement. Now, I don't think there are many bride and grooms or members of their extended family or photographers that would mind that kind of use. Among other things, it probably increases their chances of being hired by you know, members of the members of the wedding or their friends. But practically speaking, no photographer wants to be in a position where they're enforcing copyright against friends of the family. You know, effectively that's really not going to happen. But the fact pattern that you described is is a valid concern of photographers, right? What comes with producing really good photographs, whatever they are, whatever the subject is, weddings, interiors, product photography, what comes with that is that other individuals and other entities like the image and images and think they're valuable. And once they are determined to be valuable, then the instinct to use them without properly licensing them is much, much higher. So it's a compliment that a photographer's work is really good and worth copying and people want it. But once, in the scenario that you described, once the image crosses over from being shared by the bride and groom's extended network to a business entity that was involved not at all in the licensing agreement, then I would argue that is a fundamental change.
But isn't the gray area for social media coming from where we have to separate what's used for commercials, let's just say advertising use? So just to keep it simple, if the catering business shared a photo from the wedding and said, "Hey, we're catering at this beautiful place today," that's one thing, and that's the gray area. But the not gray area is if they just add it to their portfolio of things for their sales on their website or on their printed brochures or whatever they do. Now they would need to license it for that purpose, where they wouldn't need to license it for the purpose of sending it to their own family or something like that. So, and then the social media brings in the gray area where everything is promotional. I mean, you have your social media users that are completely, let's just say retired to keep it simple, and they're just sharing for fun with their family, and then there's that. But a lot of social media is promotional, and so that's why I find it gray compared to where you need to license it.
Yeah, and so what you're describing is really more of a distinction between damages. So infringement is very easy to prove. Unauthorized copying, you've infringed. The difference is effectively, whether or not they're damages to infringement. So even if you had someone that drew a really hard line in this wedding scenario and wanted to go after individuals that posted a photograph of a wedding on their personal social media feed, effectively the damages would be nothing, right? What's the market value for an image being used by an individual for no commercial reason?
No, exactly. And that's why I don't think it's really comes up as an issue. Plus, I would say that if we're using the wedding as an example, that sounds like what the images were intended for anyway, was to share stuff about the wedding all over the place. So that might be, maybe our example isn't perfect, but you're right. I think that I'm telling you, the lawyer, that you're right. There are, in my opinion, there are no damages there. Yeah.
Yeah, and that's damages are pretty good. Whether or not people discuss the matter with as much specificity as we're discussing it. Effectively, most lay people know the difference between something where there is kind of notable important damages and when there's not. Most lay people know the difference between the other part of the facts that you described, where an entity that it really has no stake in personally in the individuals in a wedding, taking an image and utilizing it for their business purposes.
Yeah.
Almost everybody is aware of that distinction, and they're arguable, kind of legitimate damages to something like that compared to individual use.
Yeah, there it comes down to where most people do know what's right. And on the other hand, some people haven't really thought it through. Like to use other examples, like I just had one since our last discussion. You weren't there, but I don't know if you heard it, but we did talk about this. And someone asked if they could use photos. They were real estate. So the new owner said, "Hey, can I use the photos for rental?" And I said, "Yeah, here's how much." And of course I never heard from them, but they didn't use them. So they didn't know, or maybe they knew and they thought, why not ask, right?
Right.
And so people tend to know what I've had some good experiences where I feel like people know what to do, and when they're told something, this is the case, and they pretty much go by it. Where Rob had different experience, where a big company, I don't know if you guys want to talk about this. There was that big company that I think personally they knew better because these bigger companies deal with that, and they went ahead and used images anyway without asking or anything. So yeah, I guess what I wanted to say is it comes down to just if people respect someone else's work, and when they don't realize the work went into it, because it's just photos, I can copy them and copy them and copy them, but they don't realize what goes into that. Once they learn, I feel like they get it. I don't know. Is that your guys' experience too?
Yeah, I mean, and just keep in mind that by the time a case gets to my office, all of the things that could have happened to, kind of make it a non-issue, they have not happened. So I'm a little biased because I get cases that have not been able to be resolved, exclusively between the parties. So, yeah. But that said,
but that's by the time it gets to you, because I think most of them get shaken out along the way.
Exactly. And I think there's probably the vast majority of issues, meaning some type of issue of copyright between the parties. The vast majority of them are able to be worked out between the parties with, a simple line of communication. But my experience is certainly at this stage in the game, meaning 15, 20 years down the road, from really the initiation of social media, people know. It is no longer excusable for individuals and even close, business entities, not at all. It's no longer acceptable for an infringer to state, well, my understanding is just people just share stuff online. More specifically, well, this is the way we do things on social media. It's a sharing platform, and I don't understand why I can't do this. I've been on the receiving end of less and less of that position. People know, individuals know that while it remains easy, there is a level or two in between making a decision that you want to copy something and doing it properly.
I think it's analogous to jaywalking. We all know that jaywalking is illegal, but people still do it anyways. And they will always look at it and say, okay, so if I cross here, will I actually get caught? And I think that's kind of where we're at right now with this, because yeah, if I'm the bridesmaid of no, I'm not going to be the bridesmaid. I'm going to be the groomsman of a wedding, and I share out the wedding photos.
Always the bridesmaid, Rob.
I'm always the bridesmaid, never the groom. Then I'm going to be sharing it out, knowing that, yes, technically this is infringing, but I know that the photographer's not going to come after me, right? But if now I'm on a 4-lane highway and I'm playing Frogger, then yeah, somebody's going to either take me out or I'm going to get fined. And I know that. And knowing that difference is, I think it's kind of common knowledge now. And I think that's kind of what it's like out there. What do you think, Dave?
Yeah, I think it's a very good analogy. To continue the analogy, I don't think anyone culturally, in the United States is going to give a jaywalker a hard time when they walk against the light in the middle of the night when there's not a car in sight or a person in sight, or I don't think anyone has a problem with that. And to be fair to the infringers of the world, I would suspect that most infringement falls into the category of the jaywalker that walks, looks both ways and walks across against a light in the middle of the night when no one's there. It's harmless, and it's effectively without a real victim. But obviously the risk in that is, I'd love to know the statistics, but statistically, there is a possibility that an image for some reason, hits the nerve of lots of people and goes viral and turns into something that it was never intended to be. And the foundation of that, the origin of that, is a result of people infringing, whether or not it's the photographer's friends or whatever. Then we have an issue. But for the most part, I suspect that most copiers, most infringers, when they perform copying, know what category they fall into. Business entities certainly know. I mean, any business entity of any that's been in business for any duration or any level of sophistication. So, I mean, every entity that has an online presence is dependent upon the use of visual material, and so all business entities of a minimum level of sophistication and experience know that it is not okay. And that's not a legal term, but it is not okay to just kind of perform elementary searches and kind of blame their unauthorized copying on I found it on Google. I mean, business entities know that is not an acceptable defense.
I personally think that we should have less legalese in our world, and not okay should be used in things like contracts and things, because just simplify it, because you have when the wedding photos are being used, they should be, I think the photographer intends them to be shared far and wide on everyone's social media. Everyone that attended should be, I think they're expecting that. However, they're going to get an email or a phone call before the image shows up in Always a Bridesmaid magazine or whatever. They're gonna know that if it does show up, you'll be on Rob's be on the cover, and and that they're gonna be the professionals that you're talking about, where they're gonna reach out and license it. Where if they don't, then that's the infringement with okay. Yeah. It's not that there's direct damages because the image was there, but from my point of view, if I take photos, yes, I can copy them freely. They could be used, and I'm not. Am I losing anything? Yes or no? That's the question. That doesn't mean that Coca-Cola can use it in their advertising campaign. They don't. That doesn't mean that they have rights to it, and if they find it valuable to sell the product, then they need to compensate me. That's where I come from. Because there isn't direct damages, and I'm just wondering if that's how it fits in the legal sense. Yeah,
that's pretty spot on. I'll give you like a short real life example that a number of clients of mine do that I think is a pretty good solution to this issue. So I have two paparazzi clients in New York City who are the hardest working photographers I think I've ever seen. Just relentless and tireless, and just they happen to be spectacular technical photographers as well. But their world, specifically concerning infringement, is very different than everybody else's, because their photographs have a shelf life and an effective value of a couple days sometimes, as opposed to 20 years. We can argue about, if they're in the right business or not, concerning, kind of the value of their work, but that's the way it is. The value of the legitimate, proper licenses is a matter of days, at the most, a month.
Then there's no value in it after that.
No value in, or close to none. And so that puts them in a position that is quite different than, let's say, real estate photographers who, following the commencement of really nice images, if they manage things correctly, stand to get kind of reuse, for a decade or more to come. So the decision that my two clients have made concerning social media is they limit their social media to outtakes. So they kind of tease the content on their social media. They depend quite a bit on their social media. They I would go so far as they encourage sharing of their posted content on social media, but they don't put their final cuts and their final edits and their what they consider their ultimately like licensable material online. They provide like the shot before and the shot after, and I think the intent is to get people interested and to seek the legitimate routes of licensing their work without themselves being the source of an image that can start down the road of being infringed, and they'll never receive proper licensing from. So I thought it's a very interesting model, which I think is a very smart one.
Just as a side note, the model for that, in case I decide to go down the route of being paparazzi, which I've been encouraged to do a few times, that the model for them is just basically to sell it to whoever wants to put it in their blog or website, or what it would have been used to. It would have been the what do you call those the rags, the Globe or whatever, I forget.
They still exist, trust me.
Yeah, so like TMZ or somebody will pay them, or okay, so they're just looking to directly sell it, and it'll go out as some crazy story that someone did something crazy, and then it'll move on, and that's it. Interesting.
Now, with the paparazzi ones, the ones that I found really interesting lately are the ones where a photographer will take an image, like the Bernie Sanders image, right, where he's just sitting, and people started making memes about those, and then that went completely viral. Now, the person who took that one image, do they have a right to it, or is it now considered a derivative art for what was it, satire or whatever it is?
Yeah, or commentary. I mean, they that happens all the time, and it's a really good question. And as a photographer, I suspect that most, if not all, photographers would love to have an image of theirs go viral, and for the corresponding aspect of that, which is for them to benefit from the proper use of the work. The problem with the fact pattern you described is that once it gets to a certain point, it is, I would argue, and keep in mind, I'm a plaintiff's attorney. I'm not a defense attorney. But once you cross into the meme area, that use is arguably fair use. I mean, if you're taking a simple image and adding things to it that are intended to be funny or you can represent our culture and the way that we look at Bernie Sanders, and things are added to the original image. Most of those, I think, cross over into fair use, even though it's blatant copying. Right? It's not. No one's disputing that the original image, is a copyrightable work. But once you start adding text, and once you start putting it in the context of sharing it on social media, when it's clearly not about. I mean, people aren't sharing that image because they love the image, and because the image is itself commentary. They're sharing the image because people have all of these takes on the image. You want to tune in to see what Saturday Night Live or what the Jimmy Kimmel Show or whatever, how they interpret the image and what they add to it. So there's a problem with that. You want to be in a sweet spot where the image itself goes viral and shows up in areas where legitimate licenses are appropriate, and not cross over into the area of memes where you're in territory that you're probably going to lose if it comes to fair use.
Yeah, because there was one. I think I saw this where there was a picture that became a meme, and it was I think it was if I remember this correctly, it was a guy holding up a poster at a rally or something like that, and he's very angry, and he's got the poster there, and people took that image, erased what was on the poster, and wrote whatever the hell they wanted, and
Right.
they started to put that out there, and then one of a corporation jumped on the bandwagon as well, took that meme, put their logo on it and their thing on it, and said, "Hey, only so and so would ever buy anything but from us," kind of thing. Made that into their ad.
Yeah,
that
is an entirely different thing.
Well, then you get into the issue of the person who is in the photo holding the sign. Now his I think that person's his likeness is being used, and that's a whole other avenue.
Yeah, absolutely. If you, we've been at this for a little bit. The common theme in a lot of our discussions is the line between personal use and advertising use. Even sometimes editorial use and advertising use. If you are an advertiser, you are in a whole different area. You are treated completely differently. And
this goes back to what I was saying before, is if that meme photo is just being used as a meme and nobody's using it to, again, sell sneakers or something, then that guy doesn't really have doesn't have a case, I guess.
No, the subject probably doesn't have a case, and the photographer probably doesn't have a case.
Right,
but
I think so.
My gosh, if an entity uses a meme like that with an individual, a clearly identifiable individual, they're in dangerous territory.
In fact, that might be something that the individual and the photographer is looking for, is to get it. Let's hope maybe someone will take it and run with it, and so maybe some company will make it their campaign for a little while.
Absolutely, and I can't think of a really good example right off the bat, but there are plenty of experiences. I mean, we're all old enough, and over the years there have been plenty of instances where business entities do the right thing. And they formally make, an individual or an image that has crossed over into kind of meme or iconic territory, and they actively incorporate that person into their advertising campaign, which is, from a copyright attorney's point of view, exactly what should happen. And they're doing the right thing by, not only treating intellectual property and the individual with respect, but they're doing the right thing legally, because they clearly have the permission of the individual, and they clearly, there's clearly some kind of compensation. But my gosh, when an advertiser does something like that without doing, what they should in terms of, at least requesting permission to use intellectual property in somebody's likeness, that's terrible territory to be in.
I got one more thing I wanted to ask before we move on to something different, because we're going down some rabbit holes, but it's my chance to do that. When you have the derivative works, like there are these examples of people using a photo, they literally write a comment on it and it becomes a derivative. Okay. But where does that end? Like, for instance, one of my pet peeves is I got to spend twice as much money on a hoodie because it has a Seahawks logo on it, because they had to pay for the licensing of the logo. So it's a cheap sweatshirt, but with that, it becomes expensive. But anyway, so where does that, like, what if I take the logo and I say, is my favorite team or whatever, or to the Super Bowl, and I make it my derivative work? Now, can I print sweatshirts and not pay? Where does this derivative thing end? Like, it was clearly that still this artwork that the NFL clearly will defend that IP. Right. So where does that end? What do you have to do?
It is. This is an issue of fair use, and fair use is a fact-specific analysis that is almost impossible to pin down and develop a hard and fast set of rules. If you are, I'll give you an example. I'll give you two examples. So the easiest classic example of where that line is exists in a series of cases called the Prince cases, and the Prince refers to Richard
Big
Prince,
fan. Oh, not
who
that guy.
is
Big
well.
fan of the one named Prince.
It's funny because the other Prince is involved in the other example that I was going to give you. So the first set of
I think I know
Prince
this one.
is Richard Prince is, in my opinion, not much of an artist at all. But what Mr. Prince does is he takes the photographs of others, like just lock, stock, and barrel, doesn't make any bones about it. He takes the photographs of others and he adds stuff, right? He writes with a little magic marker. He scratches out people's faces, and I'm not a big fan. There's a series of cases because, as you might expect, photographers don't like this. They don't like, number one, they don't like their work being messed with, but they also don't like the idea of some, pop artist turning around and selling the work for tens of thousands of dollars for doing close to nothing.
Didn't that Mr. Prince, wasn't he the one that literally just added a comment on the Instagram, took a screenshot, said it was his, and had like a printed art show? Isn't that?
I don't know about the specific facts, but you're not far off from some of the examples of what he did. So there's a series of cases where Mr. Prince is a defendant. In some cases, depending on the facts, it was his work, his derivatives works were held to be fair use. There's another group of cases where his additions to other photographs were deemed to be infringement. So it's fact specific, and if you look at the changes that he made, if you line all of the original works and Mr. Prince's additions up in all of these cases, there's a pretty, you can kind of determine where the line is, and obviously it's subject to a specific judge or a specific jury, and in certain cases, but there is no, it's a very long-winded way of saying there is no like hard and fast rule. So the second Prince case is, we are on the verge, the copyright world is on the verge of learning about, what is likely to be the most important copyright decision in probably the last 30 or 40 years, and that's the Warhol versus Goldsmith case. It involves an original photograph of the artist Prince. It involves Andy Warhol's, when he was alive, his derivative work of that image. And I wouldn't expect the court to, in their holding, to establish any kind of hard and fast rules, but the opinion will guide us, for the foreseeable future, concerning, generally speaking, what is accepted as fair use and what is not. I happen to be biased because the defendant in this case, strangely enough, the defendant is the photographer, Lynn Goldsmith. The plaintiff is the Warhol Foundation. The Warhol Foundation actually filed a suit against Ms. Goldsmith asking for a declaratory judgment that they did not infringe. So let's think about that for a minute. But
Wow.
My bias is obviously with photographers because, in the end, I think the question that, regardless of the four detailed elements that our judges are required to take into consideration to determine whether or not something is fair use, ultimately, I think all of us have a pretty good, tight idea of what feels right and what doesn't. If you look at the two images at issue in the Goldsmith case, there's some changes, but fundamentally, it is Miss Goldsmith's photograph, right? He changed it, he simplified things, he added a little bit of color, he drew a couple lines. But the question I always ask myself, which I think is very fair, is what is the viewer looking at? Is the viewer looking at essentially the same rendering of the the subject of the photograph? And if you answer yes, then it shouldn't be it shouldn't qualify as fair use.
So does this fall into the same kind of category like a photographer household names should include the person that got the iconic like Che Guevara shot and the iconic the shot that of Obama that got made into the Hope poster and all those got but I don't, my understanding is that they don't really get anything, any kind of compensation from those things.
Yeah.
To me, it's a shame, and I don't know the answer, but I just think it shouldn't be that way.
Yeah. And it's the Shepard Fairey case, the Obama image case, is a really interesting one. It was resolved. I think there was a suit. Don't quote me, but I think there was actually a suit that was very quickly resolved. And the way I understand it, the parties walked away with an amicable solution. They it was, in the end, it was not very contentious, and everyone walked away happy. But
Good.
I think you're right that the artist, once something kind of gains, kind of iconic stature, I think it's very difficult for the original photographer to leverage that into anything that resembles adequate revenue. Mm-hmm. That it's kind of, it takes on a life of its own, and either it ventures into the kind of the meme territory, or the kind of the hopelessly futile effort territory, where there's so much widespread use of the image that you just can't pin anyone down.
Do you see? This might be coming out of left field. Do you see smart contracts helping in this in any way?
What do you mean by smart contract?
I'm blindsiding you here. It's one of these blockchain solutions that lets you. People call it NFTs now, which I really dislike, because that before it was called NFTs, it just where people think it's just money making thing, but you can build in to blockchain. You can build in your intellectual property, and you can even create smart contracts. And it's in its nascent stage. Am I using that word right?
Yeah.
We're all kind of waiting, like, how can we use this in a user interface type of way, where I could say, like, you can on the simplest side just register your IP in a better, more modern, cheaper way. But you can also build in the who owns what, like who's in the image, if it's a model, if it's a space, if it's a production team, whatever, pay the key grip, I don't know. But when you use the image, then it would just get, you could have a system that automatically compensates them. And it seems like a solution is coming for this. And
yeah, I happen to think conceptually, I'll just call them NFTs, just because that I'm used to using that terminology. Fundamentally, the idea of NFTs is a very, very good one. I mean, the idea that, however we want to define it, a system is put in place that is verifiable and public, and produces an accurate record of both the chain of custody, as well as kind of the buying and selling of an original work. That fundamentally is almost impossible to argue with, right? I mean, that's the way things should be. And on an intellectual property level, it produces one more level of accountability when things go astray. The only thing that I must confess I don't completely understand is, you have to, not you, but we all have to buy into it, right? If you as an individual decide that you are not going to participate in the NFT system, then there's really no way that you can be forced to do so. But the most interesting part of the NFT model, I think, is the idea that an artist that creates an original work in theory, depending on how the NFT is set up, benefits every single time the work appreciates in value. So, which up to now has never been the case. For example, Van Gogh never sold a work during his lifetime. Everybody else from that point on has benefited, immeasurably from the appreciation of the value of his work, as well as the buying and selling. And the original artist, the copyright holder, and his estate have been completely left out. The average person we would all agree that is fundamentally unfair. The NFTs have the opportunity to write that in the way I understand it is built in a system where anytime the work is bought and sold and anytime it appreciates, it's built in that the original author and whoever else is built into the original NFT benefits from that.
Right.
That intellectual property aside, that the way I see it is a tremendous benefit to operating under that system.
Yeah, I think and I dropped off for a second, so forgive if I repeat something that you guys said, but that applies to all different areas. So we're a photography show, so we're kind of focused on that, but it can apply to music, different kinds of art, just about anything. And I really kind of don't like the fact that NFTs, let's say, blew up for about a year and everybody was going crazy and they were making NFTs of little, I don't know, NBA plays and stuff like that. And it's unfortunate because it just kind of missed the point where I've been advocating for this for a few years since I found out how this works. And it's a little bit of a chicken and egg problem where there's the adoption versus the usage, where we just need to have it become generally accepted. And I sure hope it is generally accepted in an organic way, because I'm usually try to avoid the legal avenues because it just gets too complicated, too expensive. Try to create and change laws. I mean, you have to get standing and you have to risk all kinds of things. So I really hope that moves forward because it can be more fair for everybody. And a lot of these topics that we talk about will be really simplified. I really look forward to that. So I hope in my lifetime we're using a solution like that.
I don't think it's inevitable, but I do think we are moving unmistakably in that direction. The world in which we operate, photography fits squarely into this category, is more and more digital. The good thing about being a photographer is that although we're not exclusively digital, we're effectively digital. There are fine art photographers that still shoot and film, that make prints, that don't scan and put their images online, but that's a minority. And photographers are set to benefit from a media that benefits works very well with NFT concept, but also is very usable for photographers. We effectively exist in a digital world. The thing that and again, I confess I don't fully understand is that, what about all the other physical forms of art that cannot be translated digitally? NFTs it's a digital currency, or I use that term loosely. It's a digital idea, and structurally it's digital. So what happens to fine art photographers whose work and value exist in print form as opposed to digital form?
Well, there's a movement too for what we call tokenization, and that can apply to anything. You can tokenize real estate, so you could have you could own a 1,000th of a building or a house by sharing it in that way. So I think that is something that'll happen. That'll come our way. But I love the fact that we don't know what it's going to look like exactly. Someone said really well, because it's no secret I'm into the kind of the blockchain, Bitcoin kind of stuff, and I just see it as the future. And when we look at it as in the analogy of the internet, it's so early. It's like 1995 internet right here. And when someone said when the internet was coming around, no one predicted Uber. And so I like that analogy because we don't know how these things are going to look, but it's clearly trending that way. And there's a huge amount of people, this huge industry building these tools, even though it doesn't get much press. It just, the only press these things get is, oh my gosh, Bitcoin crashed. That's the only thing you ever get. But there are all these solutions that are coming under the hood, and it's rather exciting that that we'll have whatever the Uber is for this kind of use in our copyright system. Yeah, Rob.
Yeah, no, definitely. And I think that, the future is going to be, it's going to be incredible for photographers. But I just want to dial it back to today. Now, you're saying that, yes, there's a lot of things that are being done today online. And one of the questions that I've come across was, like, when doing my online course, people keep on saying, to get your clients to sign off on a license agreement or a contract beforehand becomes kind of cumbersome when it becomes a routine kind of thing. Like with us, we do real estate photography, and I teach how to do real estate photography. But to get a realtor to sign a contract every time we shoot a house is ridiculous. And so the question came up, what if whenever we're booking something, just like when you're buying anything online, they have the terms and conditions, and there's this little button that says, by clicking here, you agree. And it goes to another page with all the terms and conditions, right? They're kind of blind signing away or agreeing to this stuff. Does that actually hold up? Does that actually work?
Yeah, I mean, it's a really good question, and I have clients that have an interface on their website exactly like you describe it. Generally speaking, something is better than nothing. I mean, I had a conversation probably with my closest friend yesterday, not about photographs, but about an NDA, whether or not they want to present a potential collaborator with an NDA before, during, after their work together. And without going into all the details about how effective an NDA is and enforceability and whatever, my point was the same as what we're discussing right now. And the point that I'm trying to make right now, which is the parties, especially the photographer, but the parties are much better served and much better off if they have at least broached the subject matter before an issue arises. You are in a much better position than if the subject matter never came up and was never discussed, and you never even remotely came close to agreeing on anything. The very fact that a photographer's website has a page that at the top of the page states terms and conditions of use of my photographs, or something to that extent, and whether or not the language contained on the terms and conditions is precise or vague or poorly written or cleanly written is missing the bigger picture, which is the parties know that there is an issue with use before a photographer executes the work and delivers the product. That alone is going to solve or make most issues moot, because the parties do not want to go down that road.
Can I guess what the defense attorney will say to their client? Like if Rob, you send something and say that you're violating this thing, they go to their lawyer, and the lawyer looks at the website, says, "Oh yeah, there's terms and conditions on there. Their case is strong, or stronger than it would be. These are the reasons that it's stronger, and this is the reasons you should just pay what he's asking or take it down or whatever." Is that what they would say?
Absolutely. I mean, it's I would go even further. Legally speaking, I've had plenty of cases where I've had photographers that have a page with terms and conditions that the user before downloading images has to click through. It in addition to the things we've mentioned, it places the burden on the copier to demonstrate why it was vague, or why they didn't understand it, or why it's not enforceable, rather than placing the burden on the photographer to demonstrate that there were in fact terms and conditions and this is what they were. It might not sound like much to a layperson. It's a huge deal. If you as a party do not have the burden of demonstrating something, you are way ahead of the game. If you are the party that is tasked or legally possess the legal burden to demonstrate something, you have an uphill battle, like absent any specific facts.
It reminds me of the difference between innocent until proven guilty and guilty until proven innocent.
Right, and to be clear, when I say burden, the burden, legally speaking, any civil matter, the burden starts with one party. Now, it's different depending on what cause of action it is, what defenses are being argued, but there is always a burden. One party always has the burden to be the one that demonstrates either like a prima facie case for infringement or an arguable defense. So if you can shift the burden to the other party, you are winning the battle.
Okay.
So, prima facie first look. What is a
prima facie case means that kind of on the surface, absent any kind of other facts, that the prima facie facts demonstrate infringement. So that is a minimum, not just infringement, but any case that is the minimum threshold for surviving a motion to dismiss. Once a case,
is that like the eyeball test?
Yeah, it is. The prima facie case and a motion to dismiss, the earliest procedural way that a defendant, opposing party, can get a case thrown out is to file a motion to dismiss which challenges the prima facie case. A prima facie case, all a plaintiff has to do is demonstrate a copyrightable work and an unauthorized copy. And when you're presenting a prima facie case, you get the benefit of every fact that you state. So all you have to state is that facts as stated demonstrate your case. That's it. Everything else comes afterwards. All the defenses, all the challenges to your statements come afterwards. A prima facie case is the simplest, cleanest way of presenting the minimum thresholds for demonstrating whatever cause of action you are seeking damages under.
Okay, so then I guess for our listeners here, then the advice would be, you know what, if you can have a face-to-face conversation with your clients and clearly understand what the terms and conditions are of your licenses and the usage beforehand, that is number one ideal. But as a secondary, if you don't have the time to do that with every client and you just want to be able to make sure that you're protected, then at least put the burden onto the other party by putting some terms and conditions onto your website that they have to click on before they order your product. Or does this work? I do this on my contracts where it says when I send the invoice, it says, by paying this invoice, you have agreed to these terms and conditions. And
that's a little bit less solid than a click-through terms online, because you're basically, it's not a negotiation at all. You are attaching terms to something, and I won't go as far as kind of that's not the way contracts are supposed to be negotiated, where one party has something that they're set to deliver, and absent prior to the current moment, they introduce something that the parties have not discussed before. You wouldn't want to be the party that goes to court with those facts. That's why terms and conditions pays is much better, because you haven't delivered.
Puts up a block to getting paid too.
Yeah, exactly. So the bigger picture again is, at a minimum, if you have discussed the concept of a license versus copyright with your client, you are going to solve the vast majority of issues. You just imagine, you never want to be a photographer when your client comes to you post-shoot and post like copyright infringement claim against somebody. You never want to be a part of a conversation where your client says something like, well, I don't understand what a license is. Like, I thought they were my photographs and I don't understand. You never want to be in that position. As a photographer, even if it's a 30-second conversation, you want to be the person that says, hey, look, we should talk about these things. This is a license. This is what constitutes a license. I'm the copyright holder. They're two different very things. You're the licensee. Specifics aside, just be aware of that, right? This is the kind of business a contract we're entering into. That will solve the vast majority of your problems, because when and if the time comes that when your client wants to know or thinks about copying the image outside the license, he's going to think, you know what? I had a conversation about this in person or over the phone or an email with the photographer. I better check.
Yeah, that's a great advice there. Now
that's what it comes down to. Yeah.
Yeah.
Hey, can I switch gears a little bit and ask a question in the one of the big topics of the day, AI, because I heard a quick story about someone who sent a letter to their landlord written by AI in the form of a lawyer. So I want to get your take. I want to get your take in a second. So while we were talking, I punched up on ChatGPT. I said, take on the, what did I say? Act as a U.S. lawyer. And then I said, write me a letter asking to remove photos because they haven't been licensed for me. I am the photographer who created the photos. And it wrote me a letter. And, it's probably what you'd expect. I'm requesting that you remove the photos, blah, blah, blah. And then there's a part about, I take my work very seriously. There's a paragraph about that. And then there's another about, please understand that my livelihood depends on licensing work, etc. So if I didn't say it was from a lawyer and I just sent this from me to them, what's your take on doing something like that?
You would be in very dangerous territory. And having nothing to do with AI, it is there. To be clear, I don't fully agree with it, but states are very testy and protective of their attorneys. And if you are not an attorney and you assert certain positions, certain legal positions, you are coming close to, if not crossing the line of practicing law without a license.
Really? I can't go and say, you legally owe me something. And
that is true, but you could do that, but you cannot assert, well, again, the devil's in the details, but you cannot assert that you have and again, it's dependent on the facts, dependent on the causes of action. You cannot assert that you have the right to file suit if you don't have the power to do so. So if it's a cause of action where you need an attorney to file, or it comes into play.
Well, wait, hold on. Small claims court. That can
right. That's different. Right. But it is, every state's threshold is different, and it comes into play much more frequently when an entity that is not an attorney asserts something on behalf of a photographer. I don't think photographers run a high risk, if any risk, at asserting their positions to be able to sue for copyright infringement. A photographer is not going to get in trouble for drafting a letter that states, I am a photographer, I have these certain rights under the Copyright Act, I have the right to file suit against you unless you do A, B, and C. They're not going to get into a problem doing that. My experience, it's when an entity that is not a law firm advocates on behalf of a photographer certain things and certain options, namely to file suit, when they don't have the option of doing that.
So, like,
doesn't it seem like the
what's that, Rob?
So, like a collection agency.
A collection agency is bound by very, very specific rules of what it can and can't do.
Huh. Okay.
Real quick, I've been to small claims court once, many, maybe 25 years ago or something. So I recall that you weren't allowed to have a lawyer. And then, but what's the threshold, like a typical threshold for a small claims court in 2023?
Every state is different. I can speak to Virginia because I filed a couple small claims cases in Virginia.
Good enough.
It's $5,000. And you are right, in Virginia, I believe, unless things have changed, that if you choose that route, you cannot be represented by an attorney.
Right. That's what I recall.
I think
too. Yeah.
I think it allows, the defendant is allowed to hire an attorney if it wants. But as a plaintiff, if you choose the small claims route, you cannot be represented by attorney. Now, you can file the exact same case in Virginia in general district court with an attorney, but the purpose of small claims court is to encourage parties to take the easy route rather than the hard route.
And make it more possible to not have to lawyer up and spend a whole bunch and try to be there for the little
Right.
guy. But what I was going to ask is, doesn't it seem like the future is here, where I could take like this? I didn't read the whole little letter, but like if I just sent dear so and so and I signed it my name and I didn't assert that I was a lawyer, but it does come up in rather somewhat lawyerly speak. Isn't that just the future that's here, that people are going to be doing that? Like, I think most people's first draft of just about anything these days is coming from AI, isn't it? Where it's something to start from.
Yeah, it's an interesting question. You know, I'm really not that familiar with the threshold, if there is one, for a photographer and copyright holder to assert something that they're not permitted to assert. Again, like, I happen to think that there should not be as severe a threshold for individuals to assert legal positions. I mean, I went to law school, I passed the bar exam, but you know, I've had some of the most contentious and intelligent and really, you know, kind of powerful arguments made to me by individuals that are not attorneys. So there's no monopoly on really good arguments. You know, just because they're made by attorneys.
In fact, this letter even, I think it does a job. It says, as the photographer who created the photos, I have not licensed. So it does really push who. I think it did a pretty good job here. I'm going to think about that some more. I can copy and paste it to you.
Yeah. Now, here's a question then. If, Ron, you use that, are you using copyrighted material?
That's wait.
That is a really good question, and the subject of I don't read all the articles, but I subscribe to a couple feeds that are just clearinghouses of kind of the daily headlines in the intellectual property world, and that type of question has overwhelmingly dominated the feeds in the past 6 months, and specifically.
Well, in the case of Chat GPT, I don't think you'd run into that, because number one, it says at the bottom, this is a free research preview. And I know that there's also a paid version, and there's going to be a ton of these. There already are a ton of these options coming up, right? And so they're going to have their own terms and conditions, aren't they? Where if you pay your whatever $20 a month, and in the few years we're all going to be paying, that's going to be one of our subscriptions is for some kind of AI. So won't that get shaken out?
Yeah. And when it comes to copyrightable work, so far the consensus is that AI generated artwork is copyrightable, and by the person that, you know, drives the bus.
I watched a whole deep dive on that the other day, and it's not just blanket copyrightable. It's another it depends situation where certain parts of it can be copyrighted. But it was really interesting discussion about what's going on, because they just had that finding, didn't they? Just have an actual decision.
There have been many, yeah.
Or some whatever the governing body put out some. We'll call it guidance.
The Copyright Office issued, I forget what they call it, but it's not a legal opinion, but it's like kind of the equivalent of a paper where they try to get out in front of issues like this. And I have not read it, but you know, we're in the infancy of having predictable case law on AI generated artwork. We're in the very beginning of the process. And in one like very short anecdote that I can't go without describing.
Bring us home. Wrap us. Drop. Give us a drop of big brain advice, and play us out, and we'll wrap it up.
I'm going to let you down, because this is strictly it has to do with AI, but I received this week, today's Thursday, I probably received Monday or Tuesday, I received a 3 or 4 paragraph response letter from an opposing counsel that's representing the alleged infringer in a matter of mine that was clearly drafted by AI. You know, it like ticks off all of these terms and is written in a way that a human attorney would have drafted something, but it doesn't. It comes like 95%. It's 95% of the way to passing off as a writing by a human. But there are all of these things that stand out that, you know, no human that I've ever met that speaks any language, let alone English, would draft in the way that this was drafted, which I thought was really, really funny. That I understand we're all busy, but unless it's, this is a whole other subject matter, but unless it's perfected and unless you can pass it off as something written by a human, it seems like a really bad road to go down, where you're turning over legal arguments and nuances to an AI machine that is going to get it almost right, but not right enough to be beneficial. Like my response to the letter was, "You got to be kidding me!" Like, if you would have read this, if you would have written this as a human and it would have sounded like a human, it would have been bad enough because it's wrong. But you didn't even kind of invest the time to write this in a way that the recipient understands it to be written by a person, and therefore, you know, I'm not going to listen to you anymore. So I'll leave you with that. Like,
okay, to be fair, I've received and read contracts and legal forms that I also had the same. They were done in the real way many years ago, and I also had the same reaction was, "You got to be kidding me! There's no way I'm going to understand nor sign nor care what you're asking me to do. Take it back."
Yeah.
So, hey, I know Rob has a hard end and got to go here, so let's have David copyright deal back again later and do this from time to time if you guys are up for it. But for now, David, tell people where to find you one more time if we didn't do that.
Yep. My law firm website is daviddeal.com, and that's my combination of my first and last name, David, and my last name is spelled Deal.
Wonderful. Well, thank you very much, David.
Check out Rob's course.
Yes.
RobMoroto.ca or com.
RobMoroto.com. I'm going international here.
Good. check out his course. I'm ronpepper.com, and also send us questions either for David or for Rob or for Pepper or for any other photography question to questions@photofocus.com, and we will see you in a week or two. All right, guys. Thanks very much. Ciao.
All right. Thank you, everyone. Have a great day.